All right. I can see on my end the attendees for this question and answer portion hiking up really quickly. And so I'm going to give some time for people to get into this room. And while I'm doing that, I just want to welcome everyone as well to this live question and answer session with a large majority of the faculty that we had presenting today for our CLE on the New Mexico Civil Rights Act. I want to first acknowledge that I understand and I know that it's really hard to stare at a screen all day. And there was a lot of content covered today. And so if you want to go back and revisit anything, we're trying to figure this out, but the presentations should be available for at least a week before your CLE registration forms are due. And so thanks, I want to give a special thanks, an internal thanks to our communication staff at the ACLU of New Mexico. They handled all of the logistics with the registration and putting together our webpage and this presentation all together, recording the presenters, and they just did a great job with that. I also want to thank our panelists for sharing their expertise and donating their time to us, not just with this Civil Rights Act thing, but for our organization at large. Every one of the people on our panel are generous with their time in helping the ACLU of New Mexico in so many ways. I'm excited to hear your questions, but before we get to questions, there is a rumor starting that Diego's or Maureen's phone from Diego might go out for auction. And so stay tuned. You know, it might be a fun fundraiser for an attorney to get their hands on Diego's phone. So in terms of how we're going to get the questions, you can raise your hand in the, if you see the function to raise your hand. If you raise your hand, I'll try to get to you to ask a question. And also, you can type questions into the chat. And I'll do my best to acknowledge all the questions that I can and to call on people who have their hands raised. So with that, let's get this going. Let's see, okay. Great, I see one question coming in from Nita. Let's call on Nita with her question.
Hi, can you hear me?
Yes.
So I am so appreciative of this New Mexico Civil Rights Act, and I understand that it was came about in the context of police brutality. A lot of my colleagues and I also are excited about it because we would like to use it as a means to an end to ensure that state agencies in the use of administrative actions are giving individuals due process. Particularly, we'd like to use it in the child welfare arena. And I guess my question is do you anticipate, because from my experience of administrative law, there is the function where you have to exhaust all of your remedies. And would you, I mean, I would anticipate that that would be a defense that someone would raise. And I'm just curious to hear if there's other things that maybe I'm not seeing in this context, but particularly when the state agency is not giving you an actual arena in which to bring your due process claims because they are not functioning like a court or even an informal court, where essentially bringing that claim and pursuing that claim is futile. because it's very apparent that they're biased in their decision-making on how they are handling processes and procedures in those arenas. So I just think that it's kind of a new novel thing. Are we completely out of line, you think, for this sort of claim? So that's my question.
Nita, if I could summarize to make sure I understand and then maybe direct it, is it if there's any sort of viability for due process claims against administrative agencies who do not provide appropriate due process? And I heard you say particularly in the children's court arena, maybe?
Yes, so you've summed it up well. And it's more like, for instance, like foster parent license revocation, things of that nature. Or you could even say state benefits under ISD. So where they go through these hearing processes, but the hearing processes are sometimes very informal, and they are in short order a kangaroo court.
It looks like Maureen, you unmuted yourself. Do you have some thoughts? Or Laura, I see you have your hand raised. Whoever wants to answer that question.
I think Laura's right.
Well, I just wanted to mention that in one thing that's good in federal case law, that you don't have to exhaust administrative remedies usually prior to making a constitutional argument. And so there's a body of case law that allows that. And so if you're in a situation where you really haven't been able to exhaust, and that's part of the reason for that rule, you still should be able to make a claim under Article 2, Section 18, I would think.
Thank you. Let's see if there's any other questions. Please don't be.
But I think that sort of begs the question as to what the New Mexico law will be on this issue. And so, we're going to preface everything we say with, we have no law yet. And so we can make some good guesses and that sort of thing. But, it's another thing that you want to keep aware of and in your sights in terms of, no, we don't need, it's just, it's a lack of due process. There's nothing in the New Mexico Constitution that says anything about exhaustion.
I'm trying to see.
Well, I'll just add that Leon and I were in the Supreme Court on Monday with our amazing counsel from Faegre Drinker arguing on the statute for prison cases, whether there's an exhaustion requirement in the habeas context and for other constitutional claims. And fingers crossed, I think the court will say there's at least some exceptions to exhaustion in prison litigation context, which hopefully we can apply to our civil rights statute.
Yeah. So Ryan, I think I'm going to direct this question to you, but Adam, Phil, anybody who wants to jump in here, it's about the conversation around Article 2, Section 10, the ability to seek damages for use of force that may not be excessive, but resulted in false arrest. Does the case law therefore support the idea that use of force, even if reasonable, could still be a foreseeable consequence of unlawful conduct? As someone who has fought situations similar to Scotta's case, LA County v. Mendez in the Fifth Circuit, this would be very welcome news.
So, yeah, I think I mentioned a little bit in my presentation, the 10th Circuit case of Cortez versus McCauley, which suggests if you have an illegal arrest that leads to an injury that doesn't rise to the level of excessive force for whatever reason, if it wasn't excessive, or I think in that case it was a quote de minimis injury, which the 10th Circuit says it's not excessive force. Cortez versus McCauley stands for the proposition that if you have an illegal arrest, you can get medical damages that may have resulted from that illegal arrest, from the force used for that arrest, even if it's not excessive.
So maybe Adam was going to chime in, but I see you nodding your head.
Yeah, I just agree with all of that. I mean, the consequences of the Fourth Amendment violation, if you get damages for anything that flowed from the consequences of the other violation.
Well, and the theory is that if it's a false arrest, then no force is justified as a consequence of a false arrest. So any force is necessarily unreasonable force if it follows from the consequence of a false arrest.
I have a question, and then I'll get to some that are trickling in. Andy, maybe this is for you, and anybody else, maybe Maureen, because I know you've done election work. I'm very, very curious if having looked at the Bill of Rights in New Mexico, if there's any foreseeable litigation you can think of for the free and open clause under that pertain to our elections. You know, I'm kind of thinking about redistricting and gerrymandering and stuff like that.
Yeah, I mean, I made the comment there's three sections that sort of go together in that regard. We've got the free and election, open claim, and then there's sections 2 and 3, which talk about our form of government. And I think the three of them together can go very, very much hand in hand for a claim to serve as a bulwark against any type of legislation that you feel somehow hinders a free and open election.
And I think part of the question on that would be whether somebody's right to vote is being limited in any way. I think that's going to be the core of anything brought under the Bill of Rights, as opposed to some other claims we see running around in terms of, you know, fraud or, you know, stealing the election or that kind of thing. I don't know whether those kinds of arguments would fit well under our New Mexico constitutional provision.
Right.
Yeah. Looks like there is a question around notice to the agency. And Maureen, I'll punt this to you because you talk a lot about this. I think it does require, under the Civil Rights Act, there's notice required within a year of when the constitutional violation would be actionable, or from the incident. But then also there's the question alludes to the Whistleblower Protection Act, which I don't know actually requires notice. And so would the notice just be very similar as a tort claims notice that you just send out that, you know, my client or so-and-so is considering a claim under the Civil Rights Act, and provide some details of why?
So the notice provision under the Civil Rights Act is limited to law enforcement, and it's generally a year, and then there's some add-on things about it in terms of if somebody has died, if they had already given it before, then that counts for the estate, and those kinds of things. And so as a matter of practice, I think anytime something walks in your door, you send out a notice and say it's under the Tort Claims Act, under the New Mexico Civil Rights Act, under 1983, you don't need to give notice, but you know, you want to give the notice just in case that you need it down the road. And so my thought was, and there's also something in that statute in the Civil Rights Act about actual notice too, you know, if they actually had actual knowledge. And so the bottom line is, I think it's not any more, I would expect it to not be any more difficult or not any more fancy than what we use for the Tort Claims Act now.
Next question, it says, Phil or anybody, from my buddy Richard Rosenstock, do you foresee you know, legislation coming trying to limit inmate litigation? I see a chuckle out of Phil. I'll pass it to you.
Well, I assume that our loyal opponents are going to suggest to the legislature that they enact a little PLRA. Whether it happens or not, hard to say. I think that Ryan, in your case in the Supreme Court, are going to tell us a lot about exhaustion. One of the major obstacles in the PLRA is that it requires exhaustion for inmates and limits damages unless there has been exhaustion. It also limits attorney's fees, and it limits damages as well. And I don't see this legislature being particularly open to the idea, but I fully expect that someone's going to try and limit this act by asking that a little PLRA be established.
I'm going to kick this one to Judge Vanzi, and it's a very similar question. Are any of the panelists concerned that overly, quote, creative uses of the NMCRA will increase the likelihood of judicial backlash in the form of overly restrictive standards, which adversely affect more clearly established legal claims?
You know, I don't see that happening initially. It's going to take a while for any of these cases to work their way up through the appellate courts. So, you know, there are going to have to be a lot of overly creative cases being brought that are being decided by the appellate courts. I think the harder issue for the appellate courts now is just going to be any court, even the district courts, being educated on civil rights law and making sure that they don't import federal law and federal standards into the state act. I think that's going to be the bigger challenge.
Great. And thanks, Judge.
Leon, can I jump in for a second?
Yeah, absolutely.
I would also add that, you know, what Judge Vanzi was saying just reminded me of the fact that, remember, you're going to be dealing with state district court judges who don't know much about 1983. That can be to our benefit, and it can also be to our detriment in bringing these cases. And so you really want to take them by the hand and lead them down, and don't start in the middle of the story of the law. I do think, you know, it's always a balance in terms of, okay, do I want to do this creative claim and with the risk of making bad law? But you've got to balance that with your ethical obligations to your client in order to zealously advocate for the client. And so there's always that balance that you have to deal with in any manner.
And just to add to all of that, I mean, our Constitution has rarely, especially in the civil context, has rarely been interpreted. So there's going to require some creativity to be bringing claims and to be creative in bringing claims under the state constitution. I mean, Andy's pointed out in his talk all the differences, you know, in our state constitutional provisions, and we will have to be creative.
Great.
Well, and I guess, Linda, the only thing I would take issue with, if a claim is brought and the only source of the right is Section 4, the inherent rights, and something like that that's so obtuse, and you get overly creative, that's the easiest thing in the world for a court to go, no, not that. I don't know what inherent rights means, but it's not that. And I think for people to overly rely on those kinds of sections, that's the biggest area where you can get a backlash, where the court's just saying, no, no, no. I think the inherent rights comes in as a booster, not as a sole source of rights. So that would be the only thing I would take issue with what you just said, is someone that comes in and that's their only claim. Oh, you violated my inherent rights.
I agree with that, Andy, for a couple of reasons. One of which is in the Mary's lawsuit, Justice Chavez, in his opinion, started with Article 2, Section 4, and then said, but I'm not going to rely on that. It's nice, you know, and so he starts his opinion with it, but then doesn't really use it other than what Andy suggested as a booster or bolster it up what he was going to say. The other thing is that I joke a lot about how I wasn't happy today, and so I'm going to sue under Article 2, Section 4, because Article 2, Section 4 guarantees me happiness, not just the pursuit of happiness. And so I really don't want, although I joke about that, I really don't want anybody bringing that lawsuit, you know, because I think we're going to get kicked out of court immediately and we'll lose any positive effect we have with respect to Article 2, Section 4.
Thanks. That's funny. So Tova, I want to mention to you about the materials. Yes, we forgot in one of the attachments to Phil's presentations. It should be up on the homepage when you click under Phil's section there, and you can email me if you don't have that.
And Leon, did we add the stuff from National ACLU that Phil mentioned in his talk?
No, I don't believe so, but maybe we can get that up there on the homepage. So yeah, I would encourage everyone to revisit the homepage over the next few days. That's kind of the place where all of the things will be for the next week. I have a question. I'll direct this to Laura. When I was a staff attorney 10 years ago, is the first time I learned how high of a burden it is to meet shock the conscience. And there's even like some language about shocking the conscience of a federal judge. And under substantive due process claims, like we hear of the craziest instances of particularly educators, for whatever reason, doing wild things, and only real viable path would have been a substantive due process claim. And then, researching shock the conscience just horrified me, and we could never, clear that burden. And I kind of think of egregious conduct by the government that falls outside of these traditional buckets that we're all accustomed to. That's what substantive due process covers. And I'm just wondering if you've given any thought to like what a good standard would be, or is it just that we think of shock the conscience different and develop that differently here in New Mexico?
I think it's an interesting question. To come up with a new structure just might be good. Something along the lines of maybe even like a deliberate indifference, not as brutal as the federal prison standard, but that applies to state government actors. But I also hope and would expect it takes a whole lot to shock the conscience of a federal judge, as it turns out. That requires like mayhem beyond what any of us could conceive of. And even if that standard were applied in our courts, I don't think the outcome would be as disgusting, frankly. But I don't know necessarily a great substitute for that or how you would argue it. The one thing I can think of is deliberate indifference. And again, that brings a whole pile of things that are not great as well. And so then would it be just going back to, what does this language mean, and what should governments be allowed to do? And I think that's what we, try to kind of push for plain language, point to a statutory scheme. We have so many more statutes to rely on, like when I was talking earlier about no right to federal police, under federal law, there's no right to police protection, but that analysis just wouldn't work in state court, and it wouldn't work because we have statutes that actually do provide positive rights in a sense. So it'll be interesting to see how that all plays out.
Great. I see Matt. Adam, I'll go to you. I see Matt Coy. How about violates contemporary standards of decency? That's a great thought.
Yeah.
That's also language. Andy mentioned the Farmington versus Fawcett case, and that case actually uses language not unlike what Matt has suggested in the free speech under the New Mexico Bill of Rights rubric. And that might be a good place to look for the language that parrots or looks like what Matt suggested.
Adam, did you have any thoughts on that?
No, not really. I was sort of concerned about pointing to deliberate indifference as an alternative. They all just seem so, they're so malleable. I kind of agree with the point that it just depends on when you get those standards, it just depends on the individual judge and what they feel like about the case. It's not a great way to be.
It's true. It violates contemporary standards of decency as well, right? I can't really envision a standard that's not going to be a little malleable when you're talking about substantive due process, and so we just need to be careful with it, because that is the main criticism of any rights under that clause to begin with. So I don't know a clear, easy answer to it, but at least Phil's right. Like the Fawcett court, there is a case that expanded you know, a First Amendment test, but it's just kind of like, I don't know, it's all pretty malleable.
And I think that it's important to remember the malleable as well as the different circumstances under which some of these rights will arise. And so you don't want to say, okay, this is the standard for a violation of this section of the New Mexico Constitution, when it might have been it might have involved a physical injury, but by using that particular language in a case where you didn't have physical injury, it might say, well, there's, you know, it doesn't apply here. I mean, so you can't have a claim under that particular provision because there's no physical injury here. So we want to make sure. I was just thinking about it in terms of Matt's suggestion about contemporary standards of decency. I like that when we're talking about somebody using excessive force or doing something wrong in the prisons to inmates and something like that. But is it really indecent to violate somebody's right to speak at a county commission meeting? You know, that the court may have trouble getting to that kind of word in a different kind of context.
Well, and Maureen, picking up on that, I don't think it's just the kind of injury. I think it's also the nature of the claim. I mean, what I keep thinking about are the foster abuse cases. When you've got small children who are in state custody and are totally dependent on the actions taken by social workers, it seems like that standard could be very, very different because there's such a sense of dependence on the part of the claimant. And so what I agree with you, Maureen, I think this whole idea that there could be different boxes of substantive due process and different standards. And you see that, by the way, in the completely different context, but in the Establishment Clause context in the Supreme Court. It's just a whole series of boxes because the standard they use for school prayer isn't the same standard they use for public prayer, which isn't the same standard they use for school financing. They seem to come up with very different tests, but they're all under the same constitutional provision.
But we don't love that, right, Andy? I mean, it is.
Well, we don't love it unless it cuts in our favor, but,
right.
But I don't think we should be afraid of it. Again, going back to Maureen's point, I don't think we should be afraid of it if we have very, very different contexts in which our substantive due process claim is arising.
Andy, don't you agree that we both talked to Michael Browdy? I mean, and Michael thinks that we should just dump all the federal standards and develop a new set of standards. Why are we looking to the federal courts at all for standards and picking and choosing? Once we start picking and choosing, we're going to lose. I mean, he even takes issue with, you know, the various levels of scrutiny. Why, under our state constitution, would we apply a rational basis, intermediate, and strict scrutiny standard to any of the Bill of Rights? So, but that's a tough question. And how do you develop new standards?
Rational basis for everything, Judge.
Yeah, right. It's our Constitution.
Yeah. Well, I just want to, go for it, Laura.
I just want to say, I mean, that really is totally doable. If you have the basic construct of the government needs to justify any restriction. And it doesn't have to be in the scheme of rational basis. It just makes sense. Like if it's a discrimination against groups that people have really good reason to discriminate against, that'll sort out whether you're applying something called strict scrutiny or rational basis. Like that's easily, and that under the Constitution, the words are like, we're not going to limit your freedoms unless it's not an absolutist thing. It is doable. And it doesn't have to look as, I mean, so much of the federal constitutional law just is a lot of rigmarole to get through what seems like personal preference often, but.
Well, that is a good note to end on. I know this was a short live session. We might be working on something when we can all meet live, and maybe even then we'll have some district court cases to look at as to see how things are developing under this law. There's so many people. I can see the attendees on my screen that I just want to say hi to personally. And I know I can't spend the time doing that, but I do want to thank everyone for attending today. I want to thank our panelists for giving so much of your time. And I know that we all mean it, that if you're considering bringing a case that invokes the New Mexico Civil Rights Act, yes, call. And you know, we're a small, inclusive, welcoming bar, and it's because of people on this panel who have mentored folks like me and are willing to answer their phone. So don't be shy about reaching out to me or anyone on this panel if you have questions about how to frame things. With that said, I'm gonna end this and go watch Space Jam 2 with my children. See ya.